The Estonia disaster is being surrounded by lots of conspiracy theories, we all know that. But something that isn't talked about much is the fact that Estonia missed a collision bulkhead behind the ramp. And that was something which was required according to the international safety regulations SOLAS. It is overshadowed by alternative hypotheses for the cause of the sinking. There are more theories about explosions, submarines, military transports than collision bulkheads behind the ramp and certificates. In the JAIC's report, this is addressed, and it is also addressed in the latest report that came in January 2023 from the Swedish, Estonian, Finnish investigation. The report is called the Intermediate Report. Estonia did not have a collision bulkhead behind the ramp, and that was a major contributing factor to the fact that water could rush onto the car deck when the visor was ripped off on the night of September 28, 1994. Because there was no collision bulkhead behind the ramp, it also meant that Estonia was not built for the Tallinn-Stockholm route. But how could that be? Who was responsible? In this video, I thought I'd try to clarify that. I found an article about precisely this with the ramp and the certificates in the Swedish newspaper Dagens Nyheter, Today's News, from February 1995, and the article describes what happened and who could be responsible. I will also read parts of the intermediate report from January 2023. It is about, among other things, the lack of the collision bulkhead and the certificates. Finally, I will also include some clips from the Swedish documentary Livlinan som brast from 2002. The documentary discussed the certificates, and a person called Jukka Hekemies from the Finnish Maritime Administration is interviewed. These are very interesting clips. But we start with the report from 2023. This is how it says: the SOLAS Convention requires a collision bulkhead that is placed on a certain distance from the forward perpendicular. On MS Estonia, the collision bulkhead was represented by the bow ramp. The vessel was built with an exemption from SOLAS Commission requirements regarding the placement of the collision bulkhead. Such an exception is conditional on restrictions in traffic. The vessel may not be used for traffic within an area more than 20 nautical miles from the nearest land. This limitation must be noted in the ship's certificate. Such an exception was never noted in the certificates of MS Estonia. Initially, there was a separate decision from the flag state that prohibited the ship from traveling further from land than 20 nautical miles. The fact that the content of the decision was not noted in the certificate led to the knowledge of ship. Traffic restrictions was lost over the years, and instead provided the classification notes no restrictions regarding ARIS or operating conditions. This means that the ship's safe operation was seriously affected and that the ship was not seaworthy. This is what it says in the intermediate report. They describe in a good way what happened and how it could happen. That explains why Estonia sailed the Tallinn-Stockholm route even though she wasn't built for that kind of traffic. The current investigation also concludes that Estonia was not seaworthy. In Dagens Nyheter in February 1995, an article was published regarding Estonia's certificate and location of the bow ramp. This is what the article says: how the fault that sank Estonia was approved. The inspectors wrote safety certificates without inspection. The shipyard blamed exemption that did not exist. By Ola Sigvardsson and Pia Skogsmark. Published February 1995 in Dagens Nyheter. If Estonia had been constructed according to the rules, she would not have sunk. The Collison bulkhead behind the bow visor had kept the masses of water out, and the ship could have returned to Tallinn while the bow visor settled on the bottom of the sea. Why wasn't the collision bulkhead where it should be? Who made the mistake that sunk an Estonia? According to research made by Dagens Nyheter, the responsibility falls heavily on the Finnish Maritime Administration. On June 27, 1980, Jan Jansson signed the most important paper of his life. He was and still is an inspector at the Maritime Board in Helsinki. The certificate he issued is called the Passenger Ship Safety Certificate. It concerned Viking Sally, later renamed Estonia. 14 years or exactly 5,206 days later, the bow visor is knocked off, the ramp inside is pulled along, and water flows onto Estonia's car deck. She sinks, and nearly 1,000 people die. Jan Jansson approved Viking Sally that day in Helsinki. Yes, he even guaranteed that she complied with the International Convention for Life at Sea, SOLAS. This is what it says verbatim. I, the undersigned, certify that the above-mentioned vessel has undergone a proper inspection in accordance with the provisions of the above-mentioned convention. That the inspection shows that the vessel meets the requirements of the rules, which is the attached convention. It is a document so important that it is framed and posted in plain view of everyone on the ship. But this particular certificate was not valid. The ship did not meet all the requirements of SOLAS. There must be a Collison bulkhead behind the visor at a certain minimum distance. On Estonia and many other ships, for practical and economic reasons, the bulkhead was placed right next to the visor. Actually, it should have been built 4 meters further back on the car deck. In that case, the bulkhead would have protected the ship even when the visor was gone. That is the idea of the rule in SOLAS. Now the ramp was torn open and the car deck was open to the waves. Count lifeboats. The question is, did Jan Jansson know what he was doing when he signed the certificate? Did he know that the ship was not up to standard? I don't have any experts, he says. I'm not involved in the ship's construction, ramps and other things. I have nothing to do with that. Jan Jansson counted life jackets and lifeboats. That was his job. Colleague Gunnar Edelman was responsible for the construction. I wasn't the one who checked the bow ramp's location, and no one else from here either, he says behind a table with neat piles of paper in the office next to Olympia Port of Helsinki. That was the routine. He says it over and over again. The routine, practice, an old habit. And he is completely calm. This is how it was. It's nothing to get excited about. Over the years, he has received quantities of ship drawings and documents that he was unable to assess. They were stored somewhere at the authority, cubic meters of paper that no one had control over. We trusted the class, he says. The authority therefore assumed that the classification society, would control the ship's construction. There are the resources, there is the knowledge. The companies are private companies that formulate their own requirements, maritime safety of boats. A ship can never be insured without belonging to a particular class. Therefore, the classification societies follow their ships from the drawing board, and over the years regular inspections are carried out. In Estonia's case, the classification is called Bureau Veritas. Blaming each other, so it is true that Bureau Veritas checked the ship, but its staff never looked at the bow ramp. The ramp placement was not part of the society's rules. That was the authority's responsibility. Why should we check that ships comply with the SOLAS rules? Why should we do someone else's job? Asks Colin Spencer, spokesman for Bureau Veritas in Paris. But the Finnish Maritime Administration trusted you. I don't think so, says Colin Spencer. SOLAS is not a fuzzy safety cosmetic. The first set of rules was compiled after the sinking of the Titanic in 1912. That there were no life jackets and lifeboats for everyone on board showed that it no longer worked to entrust maritime safety to ship owners, shipyards, and classification societies. Today, the UN agency IMO, International Maritime Organization in London, regulates SOLAS. When a country adheres to SOLAS, it is required that all countries' maritime laws are changed so that they connect to SOLAS. In practice, SOLAS becomes law. Finland, as well as Sweden and Estonia, have signed. Tough demands are placed on the country's maritime authorities. They must check lifeboats, radio communication, fire safety, and, for example, the Collison bulkhead on the car deck behind the visor. In addition, there is a detailed description of how the inspections are to be handled, because it is the authority that is responsible for everything that is in SOLAS. The class has to content themselves with watching and having opinions. In each individual case, the authority must fully guarantee that inspection and review have been fully and effectively completed. That is why SOLAS was once created. To place the responsibility for the security of the country of independent authorities. There is a possibility to make exceptions to the SOLAS rules, for example, the collision bulkhead. Voyages can be granted if the ship is on international routes, a maximum of 20 nautical miles from land, but exceptions may not be made when you feel like it. It is required: 1. That the authority establishes an exemption certificate. 2. That the exception reported to the IMO so that the IMO can notify other states if necessary. No exceptions. But the Finnish Maritime Administration did not make an exception for Estonia. There was simply no exception certificate for the construction of the ramp. The Finnish authority did not want anything to do with the pre-ship construction, appears from a letter to the company Von Tell in Gothenburg that would supply visors and ramps to the shipyard in Germany. The company wanted to know which detailed drawings to send to the Finnish Maritime Administration for approval. This is how Gunnar Edelman replies in a dated letter, December 27, 1979. Regarding the bow and aft, the ramps, side doors and the visor, we assume that drawings are primarily reviewed by Bureau Veritas. The Maritime Administration lacks the capacity for routine review of all drawings materials a modern ship requires. Gunnar Edelman doesn't want to know anything, but the yard knew that there must be a collision. Bulkhead on car deck a few meters behind the visor. It was nothing new to Meyer Shipyard in Papenburg, northwest Germany. When Viking Sally or Estonia was specified in the contract between the Sally Shipping Company and Meyer, this bulkhead was written off in a simple sentence. A claim that the shipyard cannot prove. There are no papers on it. The shipyard is currently looking in its archives for a document, says Peter Holte-Pels, leader of the Accident Commission appointed by the yard. And the Finns have no idea. We didn't even know the ramp was in the wrong place, says Maritime Director Heikki Valtonen. Solus distinguishes between two different types of inspections. A thorough one when the ship is put into use for the first time when, among other things, drawings are reviewed. The one that Jan Janssen certifies on 27 June 1980. Then follow annual inspections, which mostly deal with the ship's condition. Between 1980 and 1992, the Finnish Maritime Administration carried out these annual inspections of Viking Sally or Estonia. In several cases, the certificates are signed by Jan Janssen. In January 1993, Viking Sally was sold to Estline, which is owned by the Swedish shipping company Nordström and Thulin and the Estonian shipping company. Estonia was going to traffic the route Stockholm-Tallinn. At the same time, responsibility was transferred from Finnish authorities to Estonian authorities. Now the old certificate ceased to be valid. Because Estonia basically lacks a maritime authority, all inspections have been outsourced to the classification societies. So Bureau Veritas, which inspected the construction in 1979 on behalf of the ship owner, now took care of the ongoing inspection, according to Solus. Estonia was in dry dock in Turku on January 13, 1993 for inspection by Bureau Veritas. The Estonian passenger safety certificate is dated 28 January 1993 and signed by Hans Olsen at the Swedish part of Bureau Veritas. We did not do an initial inspection. That's what you do when the ship is new, he says. We carried out a regular annual inspection according to the requirements of Solus. Jan Janssen's signature from the first certificate in 1980 guaranteed that an initial inspection was done. The error of origin followed from the Finnish authority to the Estonian one, and Estonia sank a year and a half later. Shared responsibility. Some believe that the demarcation between different areas of responsibility at sea is clear, like Bureau Veritas, others that it is a grey area, for example the Finnish authority. What is clear is that the responsibility is distributed among many countries. The shipping company has overall responsibility for the ship's seaworthiness. In this case, Estline has little chance of knowing the ship's fundamental faults. All papers that were supposed to be included with the purchase and showed unequivocally that Estonia was in compliance with all the rules. The captain is also responsible for safety, nor does he seem to know anything that should have set alarm bells ringing. The shipyard has a product liability and its designers deliberately deviated from Solus rules with reference to the Finns. But the ship was actually approved. What remains is the authority that approved Estonia, which guaranteed that she was built in accordance with Solus even though she was not. Jan Janssen's signature cannot be reasoned away. He represents an authority that did not even look into the basic construction of ships or how Solus works, an authority which in each individual case must fully guarantee that the ship matches Solus, but didn't even know where the ramp was located. Does this mean that Jan Janssen is responsible for Estonia's breakdown? No, says Anna Christensen, professor of civil law at Lund University in Sweden. The development is increasingly moving towards an individual employee not being held accountable from the point of view of damages. The responsibility falls on the employer, but in this case it is time-barred as far as I understand. From a Swedish perspective, Estonia raises more questions. The Swedish Maritime Administration has acted like the Finnish one. The class kept it technical, and the Maritime Administration dealt with lifeboats and fire extinguishers. Estonia's sister ship Diana II was built by a Swedish shipowner and was approved by the Swedish Maritime Administration with the same bow design as Estonia and, like Estonia, without any exemption certificate being issued. The difference is that Diana II is still afloat, now under the name Mare Balticum on the Tallinn-Stockholm route, today with a newly built steel bulkhead in the right place. It is strange to think that we in Scandinavia thought we had the world's safest ships, says Börje Stenström, technical expert in the Accident Commission, and so we sailed around without following the most important safety rules. There are many ways to interpret SOLAS details, but when it comes to the Collison bulkhead, there is no room for interpretation. At Norrström and Thulin in Stockholm, the Vice President Sten, Christer Forsberg, handed over Jan Jansson's certificate. "I get scared," he says. "If only we had known, we would have rebuilt Estonia. Then she wouldn't have sunk even if the visor fell off." So I ask myself, what is the point of all the paperwork? Here we get nice documents from the Finnish Maritime Administration that say that the ship meets the requirements, and then it turns out she doesn't. What is the paper then worth? This article is, as I said earlier, from February 1995. I think this and the latest inquiries report are the summaries of how things could go the way they did with Estonia, the certificates, the bow ramp, and so on. In the documentary Livlinan som brast, a number of people are interviewed about this, the exception of the SOLAS rules and the wrong location of the ramp. This is what they said in the documentary. Bureau Veritas inspectors do not detect the ship's exceptions. They do not detect the illegal practices of the authorities. But there is no doubt that it is the Finnish Maritime Inspection, and thus the Finnish state, which bears the legal responsibility for the fact that the ship lacked an exemption certificate from the start. This Scandinavian practice, it was there, not on paper. A lot of ships have been approved even though the ramp was in the wrong place. But who would you say bears the legal responsibility that there was no exemption certificate? Legally, that's what I mean. Legally, the employer is responsible for all mistakes made by employees. In short, the state bears the legal responsibility for all its certificates. It was some time back in the 70s that a practice of some kind developed. But how it came to be, well, then you can go back to my representatives. Because it was before my time here, so I have no idea. We went through all the certificates. There were no restrictions whatsoever in the certificates for the route Tallinn-Stockholm. After having read through all the documents relating to this and watched the documentary several times, it is clear that there was a system error in shipping industry when the Viking Sally was built, and even later. Several ships had been built as Estonia and was approved even though the ramp was placed in the wrong place. All this because of this Scandinavian practice. I think the intermediate report sums it up very well. An inspection of the parts of the bow was never carried out. The certificate should not have been issued if such an inspection had not been carried out, which means that Estonia was not seaworthy. If such an inspection, according to the regulations, had been carried out, the flaws in the visor construction could have been detected and the accident probably would not have occurred. The placement of the bow ramp as the extension of the collision bulkhead was based on a practical decision to obtain exemptions from the rules. Such an exception entails a condition that must be documented in the certificate, but it was not done. Therefore, MS Estonia was not seaworthy and the certificate was incorrect. If the condition had been noted in the relevant certificate, the ship had not operated on the Tallinn-Stockholm route. You can only say that the disaster was completely unnecessary and could have been avoided. And this is much more serious and more outrageous than any conspiracy theory out there. At the time of the disaster, this was a real problem. None of what I have talked about here is news. This has been known since the end of the 90s and the beginning of the 2000s. After the disaster, measures were taken on board vessels of similar construction to Estonia. Among other things, bow visors were welded and collision bulkheads were built where they should be according to the rules. Now almost 30 years have passed since the disaster, and a similar accident has not occurred since then, so something has been learned. But it is terrible that almost 1,000 people had to perish before any changes were made.